defendant detained for 7 days to facilitate completion of investigations. The grounds upon which the orders are sought are set out in the face of the motion and supported by an affidavit sworn by Inspector of Police Nicholas Njoroge as investigating officer. In short, he gave us reasons for seeking the orders: the need to complete investigations, the need to contact authorities in different jurisdictions that the transactions involve. And he also cited the need to record statements from witnesses, some of whom are outside the country. And to subject one mobile phone to analysis. In addition, learned prosecution counsel Mr. Rome stated that the offense being investigated is a conspiracy involving other players yet to be arrested. He stated that if released on bond bail terms, there was a high probability that he would interfere with the investigation. Through defense counsels Ms. Kisoi and Mr. Uduk, the respondent opposes the application. In a nutshell, their position is that the application is devoid of merit. Ms. Kisoi submitted that the respondent is a family man and a well-known businessman with a fixed abode. He stated that he is ready to cooperate with the investigations and was ready to avail himself to investigators as and when required. Mr. Uduk cited the Constitution and faulted the state for not providing compelling reasons. He justified the detention of the accused persons. He stated that the orders sought were intended to deprive the respondent of his liberty without justification, thereby infringing his constitutional rights. So the rights of an arrested person are guaranteed under Article 49(1) of the Constitution. And they include under Article 49(1)(g), at first court appearance, be charged or informed of the reason for detention continuing or to be released, and H, to be released on bond or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. And the standard of proof imposed upon the prosecution in establishing compelling reasons for denial of bond or bail is on a balance of probabilities. Therefore, the only issue for determination is whether there are compelling reasons disclosed to warrant the grant of the order sought. In Sharif Mohammed and 4 others versus Republic, it was held that in applications such as the present one, all the court needs to satisfy itself is that there are good and sound grounds upon which the prosecution requires to hold a suspect for a reasonable period. So in the objection to the application, Ms. Kisoi for the respondent has pointed out that our client is not a flight risk. This point is not contested. The greater concern of the prosecution seems to be having the respondent cooperate during investigations and not to interfere with the investigations. An arrest should only be effected where there are sufficient grounds. And those grounds can only be sufficient if the police, through proper investigations, have prima facie evidence which can enable such person to be charged with a disclosed offense. So by the reasons enumerated for seeking the orders, the applicants inadvertently reveal that they have no prima facie evidence, just that a report was made but no investigations have yet been done. So therefore it is likely that investigations did not commence prior to the arrest. I am therefore of the considered view that all that is sought to be established against the suspect can be achieved even if the suspect is at liberty. He has undertaken to avail himself to the investigators and to cooperate with them. I am convinced that he intends to do just that. because I note that the amounts disclosed are colossal, it's only fair that as a safeguard there is some bond or bail attached to his release. For these reasons, I find that the objection to the application succeeds, and I admit him to a cash bill of 500,000 and one credible contact person.